For 20 years, one phrase sat at the center of Fourth Amendment law, and nobody could fully agree on what it actually required. Objectively reasonable basis. 4 words, first written by the Supreme Court in 2006, describing when police can enter your home without a warrant to help someone in danger. And for 2 decades, courts across the country quietly drifted in opposite directions on what those 4 words actually meant, some demanding something close to probable cause, others accepting something closer to a hunch. On January 14th, 2026, in a case with one of the more unusual names you will see at the Supreme Court, a man literally named Case, the court finally nailed that phrase down, unanimously, all 9 justices, and resolved a split that had been building for years across federal circuits and state Supreme Courts alike. If you want to understand exactly how the court got there, not just the headline outcome, the specific statutory and doctrinal moves the majority made along the way, this is the breakdown. Quick housekeeping. I cover Supreme Court rulings the way the opinions themselves are actually written, tracing the reasoning, not just reporting who won, because the reasoning is what determines how the next case gets decided. If that is useful, subscribe and turn on the bell, because this particular doctrine is already being tested in new fact patterns in the lower courts, and I will be covering those the moment they are decided. 2 seconds, and let's get into the actual legal mechanics. Start with the doctrine itself, because understanding where it came from is the only way to understand what the court just did to it. The Fourth Amendment generally requires police to get a warrant before entering a home, a rule the Supreme Court has repeatedly called the point at which the amendment draws its sharpest line, reflecting the deep historical American suspicion of government agents crossing a private threshold uninvited. But that rule has always had exceptions. Situations where the ordinary warrant process would defeat the entire purpose of acting quickly, exigent circumstances involving hot pursuit of a fleeing suspect, the imminent destruction of evidence, and the one relevant here, the need to render aid to someone in danger. One of those exceptions, the emergency aid exception, allows officers to enter without a warrant when someone inside may be seriously injured or in imminent danger. The court first clearly articulated the modern version of this exception in a 2006 case called Brigham City versus Stewart, which began, almost incongruously, with a noise complaint. Officers responding to that complaint looked through a window and saw a physical fight in progress, a juvenile throwing a punch hard enough to draw blood from an adult. They entered to stop it. The Supreme Court upheld that entry, writing that police may enter a home without a warrant when they have, in the court's exact phrase, an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. In 2009, Michigan versus Fisher applied the identical standard to a different scenario entirely, a disturbance call where officers found a damaged truck, blood, and a yelling, bleeding man inside a house, and reached the same conclusion. Here is where the doctrine got genuinely murky over the following 15 years, and it is the specific problem the court had to clean up in this case. Courts around the country kept applying the words objectively reasonable basis, but they did not all mean the same thing by it. Some courts effectively imported probable cause into the standard, treating an emergency entry the same as any other warrant exception and demanding the same rigorous showing used to justify searching for evidence of a crime. Other courts drifted the opposite direction, especially where states had their own community caretaker or community caretaking doctrines layered on top of the federal standard. Doctrines that in practice often ended up describing something closer to reasonable suspicion, the much lower bar used to justify a brief investigative stop on the street. By the time this case reached the Supreme Court, you had federal circuits and state Supreme Courts effectively applying 3 different versions of the same 4 words, which is precisely the kind of doctrinal drift that eventually forces the court to step back in and say clearly what it actually meant the first time. This kind of drift is not unique to Fourth Amendment law. It happens whenever an appellate court articulates a standard using general language, objectively reasonable, clear and convincing, substantial evidence, and leaves it to dozens of lower courts across different jurisdictions to apply that general language to wildly different fact patterns over many years. Small variations in phrasing compound over time, one court's gloss becomes another court's starting point, and eventually the original standard has effectively split into several different standards all wearing the same name. Fixing that kind of drift is one of the quieter but genuinely important functions the Supreme Court performs, distinct from resolving hot-button constitutional controversies, and this case is a clean example of exactly that function in action. Now, the facts of the actual case, because they matter enormously to understanding how the court applied the standard it was about to clarify, and because the specific sequence of what officers knew and when is exactly what the totality of the circumstances analysis turns on. William Trevor Case called his ex-girlfriend and told her he was going to write a note and kill himself. During the call, she heard a sound consistent with a gun being cocked, then what sounded like a shot, then silence. She called 911. Montana officers arrived at his home, knocked, and shouted into an open window, getting no response. Through the window, they observed an empty handgun holster and what appeared to be a suicide note. After repeated failed attempts at contact, they entered without a warrant. While clearing the residence, an officer approached a closet where Case was hiding. He suddenly opened the curtain holding what appeared to be a firearm. Believing he was about to be shot, the officer fired once, wounding Case. A handgun was later recovered in a nearby laundry hamper, not in Case's hand at the moment of the shooting. Case survived, was charged with assaulting the officer, and moved to suppress all evidence from the encounter, arguing the warrantless entry itself violated the Fourth Amendment, a motion that, if successful, would likely have unraveled the prosecution's entire case against him. The trial court denied the motion. A jury convicted him, and the Montana Supreme Court affirmed 4-3, applying the state's own community caretaker doctrine, requiring officers to have, in that court's language, objective, specific, and articulable facts to suspect someone needs help, with 3 dissenting justices on that state court already disagreeing about how that doctrine should have applied even before the case reached Washington. The Supreme Court granted certiorari specifically to resolve whether the emergency aid exception requires probable cause or a lower standard, and Justice Elena Kagan wrote the opinion for a unanimous 9-justice court, an outcome that is itself worth noting given how often Fourth Amendment cases split along more predictable lines given the underlying tension between individual privacy and law enforcement authority that runs through nearly every case in this area. Her reasoning proceeds in 2 connected steps, and both matter independently. First, she rejected probable cause as the governing standard, explaining that probable cause is conceptually tied to criminal investigation. It measures the likelihood that evidence of a crime exists somewhere, a fundamentally backward-looking evidentiary question. Emergency aid entries are neither backward-looking nor evidentiary. They ask a forward-looking, safety-focused question: does someone right now need help? And importing a criminal investigation standard into that context, in the court's words, would fit awkwardly at best. Second, and this is the part that resolves the actual doctrinal murkiness that had built up over 15 years, Kagan wrote that Brigham City's reasonableness standard means just what it says, with no further gloss. That sentence is doing very specific legal work, the kind of sentence litigators will be quoting directly in briefs for years to come. It tells every lower court that has been quietly raising the bar toward probable cause that they were wrong, and it simultaneously tells every lower court that has been quietly lowering the bar toward mere reasonable suspicion that they were also wrong. The court fixed the standard at exactly one point, not floating between 2 competing pressures the way it had functionally been drifting for years, and it did so using language precise enough that it leaves very little room for a lower court to reintroduce the same drift through a slightly different formulation next time. That second half is precisely where the Montana Supreme Court itself had gone wrong, which makes this something more than a simple ruling in favor of the government. The court specifically identified that Montana's community caretaker doctrine, focused on objective, specific, and articulable facts, actually tracks the language of reasonable suspicion, the standard from a completely different area of Fourth Amendment law governing brief street stops, not home entries. So while the ultimate outcome upheld the officer's conduct in this specific case, the court simultaneously corrected the Montana Supreme Court's legal reasoning for getting there, affirming the judgment while explicitly not embracing all of the reasoning beneath it, a distinction that matters enormously for how Montana courts and any other state court using similar community caretaker language have to analyze the next case. 2 justices wrote separately despite joining the unanimous outcome, and both concurrences sharpened specific edges of the majority opinion worth understanding on their own. Justice Sotomayor's concurrence specifically flagged that the Montana Supreme Court's opinion appeared, in her words, erroneously, to apply a standard lower than objectively reasonable basis, essentially underlining for lower courts everywhere that this decision cuts in both directions, not just against imposing probable cause. Justice Gorsuch wrote separately as well, tracing the doctrine's roots through the court's own precedent in more detail, joining the majority's reasoning in full while adding his own account of how the emergency aid exception fits within the broader structure of Fourth Amendment exceptions to the warrant requirement, situating it alongside hot pursuit, the destruction of evidence, and other recognized exigencies as a distinct branch of that family rather than a subcategory of any of them. Neither concurrence changes the governing rule, but both signal, from two justices with fairly different overall judicial philosophies, one generally associated with a more expansive view of individual rights, and the other with a more textualist, history-focused approach, that the precision of exactly where this line sits mattered enough to write about separately even in a unanimous case. A genuinely useful signal for anyone trying to gauge how durable this standard is likely to be against future challenges from either direction. Apply that clarified standard to the actual facts, and the court's conclusion becomes fairly mechanical, though it is worth walking through exactly how the totality of circumstances analysis actually operates, because that is the transferable lesson for future cases. The officers had, layered together, a direct, contemporaneous report of a suicide threat, the sound of what seemed to be a gun being cocked and fired during that same call, the call going completely silent immediately afterward, an empty holster visible through a window, an apparent suicide note also visible, and no response whatsoever after repeated attempts at contact. No single one of those facts, standing alone, would necessarily justify a warrantless entry. A suicide threat alone, reported secondhand, might not be enough on its own in every circumstance. But the court's method is not to isolate facts and test each one individually against the standard. It is to ask whether the full combined picture, viewed objectively from the officer's position at the time, supports a reasonable belief that someone needs immediate help. Here, it clearly did, and the court said so without much difficulty once the correct legal standard was actually applied to the full set of facts, rather than any single piece of it. This is worth pausing on because it illustrates something important about how totality of the circumstances tests function generally across Fourth Amendment law, not just in this specific doctrine. A defense attorney arguing against an entry will often try to isolate and attack each individual fact. The holster alone does not prove anything. The note alone could have been something else. The silence alone could mean he just did not want to talk to police. Each of those individual attacks might even have some force in isolation. But the court's method explicitly rejects that fact-by-fact dismantling approach in favor of asking whether the assembled picture, all of it together, viewed the way a reasonable officer standing at that door would have viewed it in the moment, supports the belief that someone needs help. That distinction, attacking facts individually versus assessing them as an assembled whole, is often the actual battleground in how these cases get litigated and decided, more so than any single disputed fact. The hardest part of the opinion, legally, is how the court handled the suicide by cop argument, because it forced the court to grapple honestly with the fact that police intervention itself carries risk. Case argued that the officer's decision to enter created the very confrontation that led to him being shot, and that this possibility should have made the entry unreasonable in the first place. The court did not brush this off. It acknowledged directly that the risk of provoking an escalation is a legitimate factor within the totality of the circumstances analysis, not something courts should pretend does not exist. But it declined to treat that risk as a categorical veto on intervention, reasoning that the officers faced a genuine choice between two real risks, doing nothing and potentially leaving a man who may have already shot himself without aid, or acting and risking exactly the kind of confrontation that in fact occurred, and concluding that choosing to act, even at meaningful risk to the officers themselves, was, in the court's phrase, at least reasonable. The doctrinal takeaway here extends well beyond this one case. The possibility that intervention could escalate a situation is a factor to be weighed, not a trump card that automatically defeats the emergency aid exception whenever it is raised. Let me flag two misreadings of this opinion that are worth avoiding, because both would overstate what a unanimous, narrow, doctrinal ruling like this actually accomplished. The first misreading treats this as a broad expansion of police authority generally. It is not. The court did not create new power. It clarified the boundaries of a power that has existed in essentially this form since 2006, and it simultaneously closed off the possibility of that power expanding further through a drift toward lower and lower standards in state courts. If anything, by explicitly rejecting Montana's reasonable suspicion adjacent formulation. This opinion constrains some jurisdictions that had been operating under a more permissive standard than the Constitution actually allows. The second misreading treats this as resolving every hard case in this area going forward. It does not. The objectively reasonable basis standard is still a totality of the circumstances test, meaning outcomes will continue to turn heavily on the specific facts of each case. This opinion fixes the legal question of which standard applies. It does not convert emergency aid analysis into a mechanical checklist that produces predictable results, regardless of the facts in front of a court. Here is what this ruling does for future litigation, which is really the point of writing a unanimous, doctrinally precise opinion in the first place. Every circuit and state court that had drifted toward requiring probable cause for emergency aid entries now has a clear, unanimous Supreme Court opinion instructing them to stop. Every jurisdiction using community caretaker-style language that functionally imports a reasonable suspicion standard now has explicit guidance that this is also incorrect. And because the opinion ties directly back to Brigham City and Fisher rather than creating new doctrine from scratch, courts applying this standard going forward have 20 years of consistent, now clarified precedent to draw on, rather than a brand new rule they have to build interpretive scaffolding around from zero. This is also worth situating against Caniglia versus Strom, the 2021 case holding that the community caretaking doctrine, developed originally for police interactions with vehicles, does not automatically extend into the home. Case versus Montana does not disturb Caniglia at all. It simply confirms that the emergency aid exception is a separate, independently well-established doctrine with its own settled standard, one that was never dependent on community caretaking reasoning to begin with, even though several state courts, Montana among them, had blurred the two together in practice. That blurring is worth understanding precisely because it explains exactly why Montana got this case wrong. Community caretaking, as Caniglia clarified, is a doctrine about routine, non-emergency interactions, most classically an officer helping with a disabled vehicle on the roadside, and it carries a correspondingly lower threshold appropriate to that lower stakes context. Emergency aid, by contrast, is specifically about serious, imminent danger to a person's safety, a meaningfully higher stakes situation that has always carried its own distinct, higher standard under Brigham City and Fisher. Montana's mistake was importing the lower threshold associated with the caretaking side of this family of doctrines into the higher stakes emergency aid context, and Case versus Montana is, among other things, a correction of exactly that specific category error. Lower courts are already putting this clarified standard to work. A First Circuit case decided just weeks after Case versus Montana applied the same framework to a missing minor investigation, where officers traced a child's digital activity to a specific apartment and entered based on that evidence combined with a parent's report. A father had reported his child missing and endangered. Investigators traced the minor's activity on a messaging app to an IP address tied to a particular apartment building, and after one tenant refused entry, another allowed officers into a common area from which they ultimately made contact with the specific unit the digital evidence pointed to. The court there emphasized two things that track directly onto the reasoning in Case versus Montana. First, that the underlying facts have to be concrete and specific rather than speculative. Mere access to technology or a general worry is not enough. Digital location evidence has to be specific and reasonably current to carry weight in the analysis. And second, that the scope of an emergency aid entry has to match the actual emergency. Officers there to locate a missing child cannot use that entry as a springboard for an unrelated general search of the premises once the immediate safety concern has been addressed. Expect more of these applications over the coming months as prosecutors, defense attorneys, and lower court judges work through exactly how this now clarified national standard interacts with the specific, messy fact patterns real emergency calls actually produce, from mental health crises to missing persons to domestic violence calls, each of which will test a slightly different combination of facts against the same now uniform standard. Step back and look at what this decision represents structurally, beyond its immediate outcome. This is not a case that expanded police power or contracted it in any dramatic sense, and treating it as either a win or a loss for law enforcement misreads what actually happened. It is a case about doctrinal precision, about a court noticing that lower courts had spent 2 decades applying the same 4 words in genuinely inconsistent ways in opposite directions, and stepping in to fix that inconsistency by reaffirming, unanimously, exactly what those words meant the first time they were written. That kind of ruling rarely makes for a dramatic headline. No side gets a clean political victory, but it is arguably more consequential for how the law actually functions day to day than a more ideologically split decision would be, because it is the kind of ruling that produces genuinely predictable, uniform results the next time a phone call goes silent and an officer has to decide, in real time, whether to open a door. Unanimity itself is worth reading as a signal here. When all 9 justices, across the court's full ideological range, agree not just on the outcome but largely on the reasoning, it usually means the underlying legal question was less genuinely contested at the Supreme Court level than the years of confused lower court litigation leading up to it might suggest. The confusion was happening beneath the court, not within it, which is exactly the kind of case where a clear, unanimous opinion does the most good. If breaking down the actual reasoning instead of just the outcome was useful, hit like, so it reaches people who want to understand how the court actually got here rather than just who won. And subscribe if you have not, because the lower courts are actively applying this exact standard to new fact patterns right now, and each new application teaches you something the original opinion alone does not, the same way the First Circuit's missing minor case already has. Tell me in the comments whether you want the next video to go deeper into Brigham City and Fisher directly, the 2 cases this ruling is built on and reaffirms without modification, or to track how emergency aid doctrine is playing out in a specific new case working through the courts this year, since both directions are genuinely worth a full breakdown of their own.